Major and surprising news out of the United States Court of Appeals for the Ninth Circuit in San Francisco, California. Specifically, the ACLU, that's right, the ACLU has submitted a brief, an amicus brief, in support of a Second Amendment case, in support of the Second Amendment. That's right, in the case of United States versus Duarte, dealing with 18 U.S.C. 922 G1, the ACLU and other nonprofit groups have submitted an amicus brief in support of the Second Amendment. Let's break it down when we get back here. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the best-selling book, Israel Disarmed, What the 10/7 Attacks on Israel by Hamas Teach Americans About the Right to Bear Arms. Check it out on Amazon. And for those of you who are going to be in San Diego for the Gun Rights Policy Conference this weekend, feel free to stop by and say hello. That's sponsored by the Second Amendment Foundation. All right, folks. So here's the story. Very interesting news, positive news, I think. The ACLU has filed an amicus brief in the U.S. Court of Appeals for the Ninth Circuit out in San Francisco, California, in support of a criminal defendant, Stephen Duarte. The name of the case is United States versus Duarte. This is a case involving whether or not Mr. Duarte can be convicted under federal gun control law, 18 U.S.C. 922 G1, which is the felon in possession statute that says that if you've been convicted of a felony, as felony is defined by federal law, which means in some instances you can be convicted of a misdemeanor and still have that constitute a felony for the purposes of 922 G1, which means you lose your gun rights for life. So the ACLU has filed a motion, or I should say a brief, in support of Mr. Duarte, because Mr. Duarte has been convicted in the past of essentially vandalism and drug possession-related crimes. No evidence of physical violence. No one is suggesting right now, or no one has established that Mr. Stephen Duarte is a violent danger to himself or to anybody else. So the ACLU has filed this amicus brief in support of Mr. Duarte, arguing that federal prosecutors, the U.S. Attorney's Office, the Kamala Harris, Joe Biden DOJ, uses and misuses this 922 G1 as an improperly, extraordinarily broad statute that punishes a lot of people with disarmament for life when they really don't deserve it. Because we've talked a lot on this channel, the way to understand when you can be disarmed is, or a person can be disarmed is, if they are physically violent danger to someone else, or possibly, theory, although Rahimi doesn't deal with this specifically, but I think it would actually get there. If you're a physically violent danger to yourself, and that is proven after due process has been given in a court of law of some sort, that you've been found to be a danger to yourself or to somebody else. Absent that, I don't see how you can be disarmed. And Rahimi, which is the U.S. Supreme Court decision from 2024, the United States versus Rahimi, essentially indicated that's where the court was going, because they said in the Rahimi case, remember Mr. Rahimi was an absolute terrible bad facts case, total, based on the allegations, scumbag, based on the allegations, the arguments about him, and the record. Now, Mr. Rahimi was found that he could be disarmed temporarily because there was a finding by a court that he was a danger to somebody else. Specifically, he was a danger to third parties, such as at the time his ex-girlfriend, for example. Now, Mr. Duarte, in this particular case in the Ninth Circuit, there's been no such finding, no such suggestion like that. So the ACLU, which again is not exactly considered, I would say, an originalist supporter, a conservative-oriented group, obviously. They're left-wing. I think that's probably fair to say, and I think they would agree with that. This is what they say why they're interested in this case. Specifically, they write the following. The ACLU has long been concerned about overbroad criminal laws, which fuel mass incarceration and racial disparities. It is also committed to advancing equal protection of the law, due process, and fundamental fairness for all, and therefore condemns criminal statutes and government actions that restrict constitutional rights arbitrarily or excessively, or that otherwise violate due process. What's also interesting, though, that the ACLU does flag gun violence, quote-unquote gun violence, as an issue. They also write the following, which is quite interesting. I'm going to tell you why in a second. At the same time, the ACLU recognizes the devastating effects that gun violence has for communities throughout the country, effects disproportionately affecting communities of color. It maintains that Congress and state legislatures can, consistent with the Constitution, impose reasonable limits on the sale, ownership, and use of firearms. Now, what I find a little bit ironic, by the way, before we get to the rest of this brief, which I generally agree with the ACLU is saying in this brief, at least about the Constitution and the Second Amendment, is I find it interesting that the ACLU is willing to step in support of the Second Amendment rights of someone who's been previously criminally convicted. Okay? Now, I'm not saying that Mr. Doherty should be disarmed for life. I'm not suggesting that. But what I am saying is, I find it interesting that I'm not aware of any cases where the ACLU has stepped in to a Second Amendment case on the merits of the Second Amendment, where the individuals fighting for the right to keep and bear arms or someone who has no criminal record. You see what I'm saying? It's kind of ironic that the ACLU is willing to jump in and defend Second Amendment rights of people who have criminal records, but I'm not aware of an instance of the ACLU stepping in to defend our constitutional rights for people that have no criminal records and are undeniably law-abiding and responsible by all measures. Just an observation. I'm not drawing any conclusions. I support the ACLU's support of the Second Amendment, so to the extent the ACLU wants to step in and support the right to keep and bear arms in any case, I generally applaud that. So I'm not criticizing them. I'm just observing something that we should keep in mind. Now, what's quite interesting is the ACLU really does point out the absurdity of this 18 U.S.C. 922 G1 and points out just how overbroad it is and how it captures so many people like a Martha Stewart who was convicted of lying to the FBI. It's ironic that law enforcement can lie to us, but we can't lie to them. But I digress. And yet the reality is a lot of people are caught in this net of 922 G1. This is what the ACLU writes about it. It is also among the broadest in scope. To secure a conviction, the government must simply establish that a person with any predicate conviction possessed a firearm for any reason for any amount of time. The person's prior conviction can just be for a misdemeanor, and a conviction qualifies even when the person did not actually receive a term of incarceration. People are convicted under Section 922 G1 for the most fleeting, innocuous, and merely constructive possession of a firearm. The statute's expansive scope thus sweeps in a vast amount of conduct that could not otherwise justify a lifetime prohibition on pain of imprisonment on simply possessing firearms. And what's particularly interesting is that the ACO cites a very interesting statistic here that says that more than 10%, I did not know this, but it's very powerful evidence, over 10% of the federal prosecutions, that's over 7,000 of the 64,000 federal convictions last year, involved 922 G1. Interesting, right? Makes it really easy to go after people with these kinds of felony convictions. Some of them, maybe they've committed predicate acts that involve violence and all that. We can talk about that. But it is interesting how extensive these federal prosecutors use this particular law. So it makes it quite important for the Supreme Court to eventually address this question. Now, the ACLU points something out that is clearly the case. It points out that Mr. Stephen Doherty, the criminal defendant in this case, is clearly part of the people. Even though the Department of Justice disagrees, the Department of Justice is still trying to take the position that someone who's been convicted of some sort of felony is no longer part of the people. Now, this is just stupid. Stupid. Okay? Because the word people appears multiple times throughout the Bill of Rights, for example. And we know that the people refers to all American individuals. Now, just think about this for one moment, why this is such a dumb argument, that being a convicted criminal, somehow pulls you out of the definition of the people in the Constitution. Well, to begin with, the Supreme Court has already said that all Americans are part of the people, as in the right of the people to keep and bear arms shall not be infringed. The Heller case in 2008 talks about all Americans, meaning everyone who's connected to our American polity. But beyond that, it's even more absurd to suggest that a convicted felon or convicted criminal is not. Because if that were the case, then the criminal procedural protections we find in the Fourth Amendment dealing with unreasonable searches and seizures and warrantless searches and whatnot. The Fifth Amendment dealing with self-incrimination, right? I plead the Fifth. The Sixth, the Seventh, the Eighth, these other procedural things like the Eighth Amendment death penalty, blah, blah, blah. The point is, once someone's convicted of a crime, you don't lose all of your rights under the Bill of Rights. In fact, for better or for worse, people that are criminals often, this is a harsh reality of it because of recidivism, people that are convicted once are often find themselves convicted of crime after crime after crime, which means they're always using the criminal process and criminal procedural protections of the Bill of Rights, the Fourth Amendment and the Fifth Amendment, and so on. They're always using those long after they committed their first crime, for example. So to somehow suggest that you lose all of your rights under the Bill of Rights if you're convicted once, which is essentially the implication of not being part of the people. And the Second Amendment means you're not part of the people for the other aspects of the Bill of Rights either. It's just plain dumb. It makes no sense. Nevertheless, this is the position that Merrick Garland, Joe Biden, and Kamala Harris's Department of Justice is currently taking in the Stewarty case. But let's go beyond that. The ACLU then goes on to say that there's no way on earth that there's a historical tradition of disarming for life people who are not violent whatsoever. Here's what they say. The ACLU writes, quote, "Notably, there is no historical precedent for such a broad ban on firearm possession. Even the early 20th century federal firearm restrictions that predated Section 922G1 applied only to narrow categories of people who either, one, committed serious crimes of violence, such as murder and rape, or two, used especially dangerous weapons, such as machine guns and sawed-off shotguns." So again, set aside the 18th and 19th century, just in the 20th century, when the modern Congress decided to get involved with this, they narrowly defined people that could be disarmed for life as people convicted of things like rape and murder, which goes back to what? You know what I'm about to say. Physically violent danger. Physically violent danger. This is the touchstone. This is what I've been telling you for over 2 years now, I believe, matters when it comes to who can be disarmed. You can be disarmed if you have been found to be a physically violent danger to yourself or to someone else. That's it. That's it. And that is essentially what the Rahimi case indicated by saying that Mr. Rahimi, who was found to be a physically violent danger to his ex-girlfriend, could be disarmed temporarily based on the facts in that record of the Rahimi case. The next part of this ACLU brief is quite good and actually gives a couple examples of the kinds of ridiculous crimes, which, are crimes, undeniably, but it's ridiculous that the implication of being convicted of such crimes means you can no longer have the right to keep and bear arms for the rest of your life. Here's a couple examples found in this ACLU brief, quite interesting. The ACLU writes, quote, "So, for example, a Navy veteran who had a single 40-year-old misdemeanor assault conviction arising out of a fistfight for which he served no jail time, was banned for life from possessing a firearm and subject to a felony conviction and years in prison if he tried." Or, to take another example, a Los Angeles man was charged under Section 922G1 based solely on a prior state conviction for possessing marijuana, a felony that the legislature had reduced to a misdemeanor at the time of his trial, and that the district attorney eventually dismissed altogether. So there you have it, folks. So the ACLU made some other arguments that I'll put a link to this brief down below in the description. You can check it yourself. But overall, they basically say that the government cannot establish the historical tradition of firearms regulation that would justify disarming for life people who have been convicted of crimes that are nonviolent in nature, and which there is no evidence or propensity to suggest that these people are dangerous to themselves or physically violent dangers to others. So the ACLU has stepped in. In this case of U.S. versus Duarte, we'll keep it on. We'll continue to track this case, let you know what happens. But I think it's a positive development that the ACLU is starting to step in on some Second Amendment cases, although I'd like to see them in some cases where it doesn't involve convicted criminals, because cases involving the Second Amendment that don't involve convicted criminals are usually a better test case to establish favorable legal precedents that we in the Second Amendment community can use in other cases down the road. Because frankly, there's a lot of people who are judges that are not particularly sympathetic to people with criminal records. It's just a harsh reality, for better or for worse. So it's always better to take a Second Amendment test case up with a party, a plaintiff, if you will, who does not have any criminal conviction baggage. But of course, in the 922G context, you don't get a lot of that, because you get a lot of criminals asserting the Second Amendment, and they have every single right to do so. All right, folks, hope hope you learned something here today. Make sure you follow me on X. We have over 18,000 followers on X now, and I think Elon Musk is doing a great job trying to allow us to have free speech in America. And don't forget to like this video and to subscribe here. We're trying to grow the channel, and we'll see you again very, very soon, I hope, here at the Four Boxes Diner.
Orders up. Table 2A.